And this campaign stopped being a campaign a while ago, and it became a movement. And yes, it all started in Loudoun County many months ago, but parents across Virginia started to recognize that they really did need to have a important, decisive role in their children's education.
A movement in Loudoun County, Virginia became the center of a national controversy regarding school policies and safety when parents accused the school board of covering up a sexual assault inside a high school bathroom. And that same teen who sexually assaulted a girl at one school was later transferred to another school while he awaited his court date. Well, last month, the superintendent acknowledged and apologized and said, quote, "We failed to provide the safe, welcoming and affirming environment that we aspire to provide." You just saw Governor-elect Glenn Youngkin saying on the campaign trail he would demand an investigation into the Loudoun County School Board and the superintendent, and he called it gross negligence. Joining us this morning, Loudoun County Sheriff Mike Chapman. Welcome to the National Desk, Sheriff. Great to see you.
Good morning, Dan. Good to be with you.
First, was this gross negligence?
Well, that's kind of a loaded term here. I would say that there is certainly a lot of misinformation and miscommunication going on. I don't know whether it would qualify for gross negligence, but the fact is that this particular individual was involved in a sexual assault in one school, and then he was moved to another, and that really did create a dangerous situation for the students at the other school.
Sheriff, we keep hearing Title IX is the reason why the student was allowed to attend that other high school and be transferred. So federal protocol, as I understand, requires schools to provide an education to an accused student until a criminal investigation is complete, right? But he was wearing an ankle monitoring device. So wasn't the investigation complete at that point? What happened?
Well, the investigation. First of all, he was charged. He was placed into juvenile detention. He was then taken out of there. There was some court process going on. There's really a question more for the Commonwealth Attorney and for juvenile intake and for the juvenile courts. Once we do our investigation, we do our investigation. We provide the information. We provide the details, and then it's a matter of hearings. And then what happens in the interim there is really largely has to do with the juvenile court and their decisions with the Commonwealth Attorney. Really has very little to do with us as far as the placement goes. It's a decision that's done by the school to put that person back in school, and that really had nothing to do with us. That was really a decision made by the superintendent.
What mistakes do you think were made in handling this investigation, and what responsibility does the sheriff's office and the school district have to make sure someone suspected of committing a crime like this is not put in an environment to possibly repeat another offense?
Well, I'm disappointed. Certainly there was a communication. The superintendent knew the day that occurred, that the assault occurred. Certainly of the incident, he knew when the individual had been charged. That had been information had been relayed to him by the juvenile intake. So it's not like the school was flying blind here. They knew exactly what was going on throughout the entire circumstances of this case. So it's really kind of up to them. It's up to the schools and juvenile court as to where it goes from there. But I do think it's a dangerous thing to take a child like that did commit a sexual assault or was certainly accused at the time of committing a sexual assault, and then put him in another school and jeopardize the safety of other people. Unfortunately, those circumstances are kind of out of our control. They really, we do the investigation, we provide the information, we become witnesses, we provide the testimony in court when necessary, and that's really where it goes from there. So we had very little to do with the placement of that individual, other than the fact that we conducted the investigation and saw it through to make sure that the information was accurate and the investigation was done thoroughly.
Sheriff, you mentioned that the superintendent knew about this the day it happened, correct?
That's correct, yes.
So this can't be common that someone reports being raped inside a school bathroom. Why do you think parents were not notified about the incident when it happened? And are there other incidents in which parents are kept in the dark, other incidents of sexual assaults that you guys have investigated that they don't know about?
Well, not to get into the complexity of the case itself, but there was a lot of information that we had to develop concerning this particular assault. Being that the victim and the suspect in this were familiar to each other, we had to ensure that in fact it was a non-consensual sexual assault. That we thoroughly did the investigation, that we were able to get the forensic evidence that we needed in order to make a solid charge on this on the suspect on this, which is what we did, and that took about a month to do. So it's not like that happened immediately. The superintendent was immediately notified of the alleged assault. It took us a while to confirm that that's in fact what happened. Once that happened, juvenile intake had notified the superintendent's office of the sexual assault and the fact that he had been charged. And then everything in between that time had to do with the juvenile court, juvenile intake, and the Commonwealth Attorney's Office and the school superintendent, public schools. Everything there happened was with them, and the decision to then put that suspect back into another school was certainly on the shoulders of the school superintendent.
Sheriff Superintendent Scott Ziegler made this claim that he has never, during his 3 years with LCPS, been notified by your department that a juvenile has been charged with a crime. What did you make of that statement that he made?
Well, I thought that was certainly a disingenuous statement. We work very closely with the school. We have school resource officers in all these schools. And by the way, most of the incidents that occur, the schools report them to us and we investigate them. So they're the ones that know about all these incidents prior to us knowing about it. It would be extremely rare for us to have an incident reported directly to us and then us go to the school. It happens most often the other way around. And so to me, that's a very disingenuous statement. And we have very good communication with them. We have school resource officers in every middle and high school. We have an outstanding program. We're nationally recognized for our school resource officer program. So for him to say that is really misleading, and I'm kind of disappointed in that statement that he made.
Last month, Attorney General Merrick Garland directed the FBI and U.S. attorney officials to address the threats of violence made against school board members. We also know a number of outspoken parents were also, they say, intimidated and harassed by some school board members and by some public officials as well. What's your thoughts on this? How do you feel about the DOJ asking law enforcement to investigate parents?
Well, I would say that any of these incidents that occur are really the laws that apply are state and local laws. In fact, when we were investigating potential threats with regards to our investigation into critical race theory that was being taught at the school system, there were some threats that came through on that. We investigated them thoroughly. In fact, we even went to the FBI and had their input on it. We went to our a federal attorney to find out his take on it. We went to an assistant Commonwealth attorney to find out outside of our jurisdiction, because the group that was promulgating the critical race theory included our Commonwealth attorney right here. So I couldn't go to her and get legal advice. So we actually reviewed this quite thoroughly and found that in order to make a threat case, there's a lot of levels that you have to do. And by the way, there are misdemeanors charges as well. So to take what's really a misdemeanor charge and usually vague threats and threats that you have to kind of track through Facebook and try to identify who's actually behind the threat and whether it's valid and all that, to take that and put that into the hands of federal government seems like a pretty far reach. I mean, we couldn't even, with the information that we had difficulty making misdemeanor cases on state charges, let alone trying to go federal with it. So I think that's a pretty extreme step to try to do, and certainly having uniform deputies there at these school board meetings as well is it can be problematic if it shows it looks like we have a use of force there that would then maybe intimidate people from exercising their First Amendment rights.
Which some say they feel like they've already had that intimidation and that they were already in a situation where they were not allowed to speak. And you said you saw that as well.
Right.
All right. Sheriff Mike Chapman, we appreciate you joining us here on the National Desk. Take care.
Okay, thank you.